Today's webinar is presented in partnership with the National Health Law Program. Today's presenter is Mara Youdelman, Managing Attorney at the National Health Law Program. This webinar will provide information on the marketplace appeals process, detailing which decisions can be appealed, how to file an appeal, and ways to expedite the appeal process. And with that, I'll turn it over to Mara.
Great, thank you so much, and thank you to the Center on Budget and Policy Priorities for inviting me to speak today and for continuing this really important webinar series. So again, I'm with the National Health Law Program, or NHELP. If you're not familiar with us, we just celebrated our 50th anniversary last year, and we focus on advancing the health rights of low-income and underserved individuals and families across the United States. You can check out our website or follow us on Twitter and Facebook. And just one important disclaimer, while I am an attorney, this presentation today is providing an overview and does not provide any direct legal advice. So let's get started. I'm going to give you an overview of what we're going to cover today, and then we'll get right into the meat of it. Our agenda is going to cover 4 primary areas. First, when eligibility decisions can be appealed, the role of assisters in appeal, how to file an appeal, and then how appeals decisions are carried out. And as Ina said, please make sure to put your questions in the question box, and we'll get to them as many as we can towards the end of the presentation. So let's get started. Marketplace eligibility appeals apply to individuals who disagree with a decision that's made by the marketplace. And it gives them another opportunity to say that they think the decision is wrong, why they think it's wrong, and what should happen instead. For consumers who use healthcare.gov, they're going to apply directly to what we call the Hhs Appeals Entity. It's also called the Federal Appeals Entity, or FAE for short. FAE is a part of the Department of Health and Human Services at the federal level, but it is separate from the marketplace. It's also the part of HHS that covers Medicare appeals, and sometimes it can cover Medicaid and CHIP appeals as well. If you are a consumer or helping a consumer in a state-based marketplace, the first round of appeals is going to go through that state-based marketplace, and then in some instances, consumers who disagree with their decision from a state-based marketplace can appeal to the federal entity. And we'll get a little bit farther in depth in that as we go through today's presentation. So the first set of issues that we're going to be talking about is what determinations can be appealed to this federal appeals entity. And it's very important to understand what avenues people have, because there actually are different types of issues or questions that are going to go to different entities. And if you just try to appeal and you don't have an issue that is in the appealable issues, you're just going to be wasting time and not getting a result that you need. So the most important thing for the federal appeals entity is an individual can only file an appeal of a determination that is final and that falls within the appropriate subject matter. There are other opportunities for consumers that we list here, and we'll go through each of these: casework, appealing with an insurer, and filing a complaint with the Department of Insurance. We'll go through each of these over the next few slides. So first, casework. Casework is an internal process that the Department of Health and Human Services operates for consumers who use healthcare.gov. It can often be used when an individual may have a very complex or challenging eligibility or coverage issue, and a call center can't help and insurance isn't able to help. If an individual is not able to get help through a call center and isn't able to get a timely decision, it might also qualify that consumer for a special enrollment period and give them a second opportunity if open enrollment is not open at the time that this happens. So in order to get into the casework system, the consumer has to call the marketplace call center, try to work it through with them, and then if the call center can't help, then they can ask to be referred to the casework system. There's more information on this from a webinar that was done back in 2015. And again, as we said, we'll be sending out the slide deck after the presentation, so you'll be able to access this link. So again, casework is really a first line of help for consumers who can't get their issues resolved through the call center. And it's often going to be much quicker and timely if someone can go through the casework system and get their issue resolved rather than having to file an appeal. So I'd say for most consumers, if they can't get help or they feel they have a wrong decision, the first line that they should be doing really is to seek out casework at this point. There are a number of decisions that insurers make when individuals enroll in qualified health plans. And many of the insurer-based decisions are not going to be appealable to the Federal Appeals Entity. There are other avenues for these individuals to appeal. But so, for example, once an individual is enrolled in a qualified health plan, if that qualified health plan denies coverage, doesn't cover a prescription, cancels coverage, or takes other actions that the insurance company or qualified health plan itself does, those must be appealed to the insurer. And every insurer is going to have a process for taking in complaints and appeals and then addressing them. If the decision that's ultimately made by the insurer is not in line with the consumer thinks that his or her rights should be, then there often is an external appeal opportunity. So an individual who, let's say, is denied a prescription at a pharmacy by her insurer, the first thing she should do is appeal that to the insurer. If the insurer still denies the medication, then the individual can appeal the insurer's decision and take that to an independent third party. And again, depending on the state you're in, you're going to have to look at what your state processes may be for this external appeal after an insurer makes its decision. Another set of issues are more appropriately handled by the State Department of Insurance. And again, these are often coming out if the insurer is taking action, and this may be that second line of defense after the internal insurance company appeal. It could be things like the insurer incorrectly terminates coverage. The insurer denies an appeal of a denial of coverage. Maybe a provider was included in a provider directory, but then later, once the consumer enrolls, the consumer finds out that provider is not in for any reason. Or if there's a violation of mental health parity laws, or there was fraud in the selling of insurance. So overall, if the issue that a consumer is facing is due to discrimination, fraud, or appealing a decision made by the insurer, the consumer is going to go to their State Department of Insurance. And again, these are going to vary state by state, and the processes might be slightly different. So your best bet for consumers in these situations is to go to the National Association of Insurance Commissioners. And again, we'll make sure that this website is available in the resources. Okay, we've now told you when not to come to the marketplace appeals. Now we're going to get into the section of this presentation where we talk about what can be appealed from the marketplace and how to go about doing that. So let's get going into the meat of our presentation here. There are a number of issues that can be appealed to either the FFM, which is the federally facilitated marketplace, or a state-based marketplace. These include things like a denial of tax credits, the amount of tax credits. If a consumer was supposed to provide additional information about their income, and at the end of an inconsistency period, an individual's tax credits were redetermined. Overall denial of eligibility to enroll or denial of access to a special enrollment period, and a couple of these other situations. In these cases, once a consumer receives a final eligibility determination, that consumer can file an appeal within 90 days. Now, for consumers in state-based marketplaces, and on the bottom of the slide, you see the 15 states that currently use state-based marketplaces. Consumers' first appeal has to go to that state-based marketplace. It's the same issues that a consumer in the federally facilitated marketplace can appeal to HHS, but if you're in one of these 15 states listed down below, you first have to appeal directly to your state-based marketplace. And then once you receive a decision on your appeal from your state-based marketplace, you can appeal to the Federal Appeals Entity if you think this state marketplace decision was wrong. There is one exception to this. It's listed on this little red X here on the slide, that if you are contesting Medicaid determinations or CHIP determinations, those aren't going to come up to the Federal Appeals Entity. Those are going to stay in your state. You'll appeal to your Medicaid agency. And if you disagree with the Medicaid agency's decision, then you'll have what's called a fair hearing. And again, you'll have to look at your state processes for that. Okay, so hopefully we've now gone through some of the issues that consumers might have disagreement with and where you can go and your best avenues for getting help. Let's now talk about when a consumer can appeal to the Federal Appeals Entity, again, the FAE for short. The first and most important aspect that consumers should know about, or if you are helping consumers file an appeal, is the eligibility determination must be final. If it includes any type of a data matching inconsistency, like citizenship status, immigration status, or income, those are not final eligibility determinations. At that point, it cannot be appealed until that determination is made final. If a consumer has a data matching issue, we call them inconsistencies or DMIs, usually the consumer is going to have 90 days to try to resolve that by submitting additional information about their immigration status, their citizenship status, or their income. Once that information is received, it will be evaluated, and then a final determination will be made. And at that point, the consumer, if they still disagree with that final determination, can appeal to the Federal Appeals Entity. So let's go through some examples here. And our first example involves Susan, who has a daughter, Alana. And on her eligibility determination, it says that she is eligible for marketplace coverage with tax credits. Her daughter is assessed eligible for Medicaid. And her daughter, Alana's application is going to be sent to her state's Medicaid agency for a final determination. So which of these are final determinations that Susan could appeal? She could appeal that she's effectively been denied Medicaid. And she's effectively been denied Medicaid because she's found eligible for marketplace coverage. So if she thinks there is an error made and she actually should be eligible for Medicaid, she can appeal that. She also, when she was determined eligible for marketplace coverage, she was granted a certain amount of tax credits. If she thinks the amount of those tax credits is wrong, she can also appeal that. What she can't appeal is Alana's assessment of Medicaid eligibility. Now, if we go back, states actually who are using healthcare.gov can make a choice how they're going to deal with individuals who look eligible for Medicaid. They can let the federally facilitated marketplace determine someone's eligibility, or they can let the FFM assess someone's eligibility. And if the person looks eligible, they're going to send that application to the state Medicaid agency, and the state Medicaid agency is going to make the final determination. So there's a difference between these determination states and assessment states. In our example here, Alana's state is an assessment state. So the FFM thinks Alana might be eligible for Medicaid. It's not making that determination, so it's not a final determination. And instead, it's going to send Alana's application to Medicaid. Now, ultimately, if the Medicaid agency determines Alana is not eligible for Medicaid, Susan can appeal that Medicaid determination with her state Medicaid agency. And also Alana's application should then come back to the marketplace and she should be determined eligible for marketplace coverage. So again, this distinction is because of whether a decision is final or temporary. And if you live in a Medicaid assessment state, it's a temporary decision by the marketplace until the state checks that application and determines Medicaid eligibility. So let's go through another example here. We have John who applied to the FFM, received an eligibility notice, and says he's eligible for tax credits. It also says that he has to prove his citizenship status. So again, this is a data matching issue or an inconsistency. If he was told he's not eligible for cost sharing reductions, let's say the FFM thinks he's slightly over income of that 250% cutoff line, can he appeal that? No. His eligibility determination is temporary because he has a data matching issue. So until he resolves that data matching issue about his citizenship, then he can't appeal the denial of cost sharing reductions. What he can do is he can go back into the application, look at his income information, make any changes. Maybe he entered a number wrong. He can make those changes. He could then get a new eligibility determination. And if there's not an inconsistency in the new determination, he could appeal that. So again, just to reiterate, excuse me, individuals can appeal final determinations, but if an eligibility notice includes any type of inconsistency, that's going to be a temporary eligibility determination, and an individual is not going to be able to appeal that until the individual resolves that, that inconsistency, or the time period to resolve the inconsistency runs out and a new final determination is made. So now that we've gone through some of what of the grounds for appeals, let's start going through how an individual actually makes a request for an appeal. And there are a couple of different ways that consumers can request to make an appeal. The first is an online appeal form. And again, we'll make sure you get this link. Individuals can fill this out online, submit it electronically, and it's probably the quickest way to get an appeal request into the system. If an individual doesn't want to do it online or doesn't have access to a computer or a cell phone to do this, an individual can have a written appeal request form and mail it in. And if consumers can't access that written request form, or they just feel that they'd be better able to talk about their situation in a narrative form instead of by filling out a form, they can just send a letter explaining the reason for the appeals. And again, they can mail that in or they can fax it, and both of them will be received and then take a note, and the process will begin. Individuals only have a certain amount of time to request an appeal. So in the FFM states, it must be submitted within 90 days of the contested eligibility determination. If an appeal is dismissed and a consumer wants to basically open up the appeal, they must do that within 30 days of the FAE saying, we don't think you have grounds for an appeal. Now, I will say, if a consumer submits an appeal and they get a letter back saying they don't have grounds for an appeal, they really might want to take a quick look, or not even just a quick look, but take a look and make sure that they're actually submitting an appeal for something that is eligible to be decided. So again, if it's a temporary decision, it's going to make sense for that consumer to finalize that inconsistency before trying to reopen an appeal and just delaying that process even longer. In state-based marketplaces, once an individual appeals to their state-based marketplace, gets a decision they don't agree with, and wants to appeal that decision to the FFM, they have 30 days after they receive their appeals decision from the state-based marketplace, or 30 days if they've requested the SBM to reopen it and it was dismissed. Now, just one slight change to these 90 days is there is a good cause exception here. So if there's a reason why a consumer couldn't file an appeal within these 90 days at the FFM or 30 days at the SBM, the individual shouldn't just give up, but should actually contact the Federal Appeals Entity and explain why they were unable to do it. So particularly now in the midst of a global pandemic, if maybe they were hospitalized or they were caring for someone who had COVID, or there were other reasons that they were unable to file their appeal within these 90 days, they should absolutely contact the Federal Appeals Entity and request this good cause exception and explain why and try to get more time to file an appeal. Now, again, just one thing I want to note here on the SBM, individuals in state-based marketplace states are going to need to look at the timeframes in their states to file an appeals. This 30 days here in this first bullet is not about how long you have to file your initial appeal with your state-based marketplace. What it applies to, again, is once you get a decision from your state-based marketplace, how long you have to appeal that decision from the state-based marketplace to the Federal Appeals Entity. So again, people in those 15 state-based marketplace states should check what the appeal timeframes are in their states, because it might be different than the FFM. Okay, another question that we often get is, well, I'm getting some tax credits right now, and I want to keep getting them because otherwise I'm not going to be able to pay 100% of my premiums while my appeal is going through. And that particularly might be the case because sometimes, depending on the time of year, there's going to be a longer period of time for your appeal to be heard and resolved. So consumers can request to have their tax credits continue during the appeal. It is really, really critical to do that when filing the appeal. It's very hard to do that once that appeal is started and once your tax credits have been shut off. There are only certain situations when individuals can ask for tax credits to continue during an appeal. We list these in the bullets on this page. So failure to reconcile, eligibility determination when a consumer completely loses tax credits, or a periodic data matching issue. These are often issues that happen because the federal healthcare.gov is actually taking some steps based on its data. So for example, failure to reconcile, when someone comes in to apply or renew their coverage during open enrollment, they have to have filed their taxes the previous year and reconciled their tax credits received with what they were ultimately eligible for. Particularly now, again, with the COVID pandemic and the IRS backlogs, individuals may have filed their taxes and it might just not yet be appearing in the IRS system because there's a delay of sometimes 12 to 16 weeks. So if a consumer receives a failure to reconcile notice and loses her tax credits, she should definitely request to have those tax credits continued while the appeal is pending, and hopefully just getting that time for the IRS to log in the federal income tax reform is going to happen and the appeal will be quickly resolved. There are a couple situations when tax credits will not be continued. So again, if there's any non-final determination, again, because this isn't eligible for appeal, or at the end of an inconsistency period, if the inconsistency is not resolved. So again, it's important to know that many consumers will be able to request that their tax credits continue during an appeal, and it's important to do that up front, but there are some situations where that's not available under the current policies. Okay, so what happens? You've now decided a consumer, or you're helping a consumer file an appeal. You've filled out that online form, or you've sent in a letter, and the Marketplace Federal Appeal Center receives the individual's appeal. So if that appeal is determined valid, then the appeal is acknowledged in writing and the process begins. If the FAE, the Federal Appeals Entity, decides that appeal is invalid, it's going to send a notice to the consumer describing if they can fix the problem and then how to resubmit the appeal request. Again, sometimes there might not be a fix because it might not be under the jurisdiction of the Federal Appeals Entity. So again, it's important to know what can and can't be appealed. So for example, here are some common instances why an appeal might be invalid. If it's filed more than 90 days after the eligibility determination notice, and there's no good cause for why it took more than 90 days. If an appeal was filed to contest a temporary eligibility determination, for example, one that still has that data matching issue rather than a final eligibility determination. Or it's filed to resolve an issue outside the authority of the Federal Appeals Entity. For example, an insurer denies you medicine at the pharmacy, the Federal Appeals Entity doesn't have authority to decide that, and you're going to have to appeal that to your insurer. So I want to go through a little bit of the terminology and the roles of someone who can assist an appeal. An appeal is really involving the legal rights of an individual. They've had a determination made, and the appeal is to say there's a legal basis why that determination is wrong, and I want it to be changed. We hear about the term authorized representative, and it often is confusing because it can be used in a couple of different places. So first, if you're helping a consumer apply through the call center, you may be designated as a third-party representative. And this person can communicate with the call center on the consumer's behalf, but can't ultimately make a decision. Like that third-party rep can't enroll the consumer in a qualified health plan. There's a distinction between a third-party representative and a little bit of a higher level representative called an authorized representative for the application. An authorized representative can actually make decisions for the consumer. And so if you're designated as an authorized representative for the application, you're actually standing in the place of the consumer. You can pick a health plan for that consumer. It's most often happening if you have a parent or a guardian who's acting in place of their child or the person who they're designated as a guardian for. We also see the term authorized representative for an appeal. And even though we're using the same terminology, authorized representative for an application and authorized representative for an appeal, in the appeal context, that authorized representative is really acting as a legal representative for the consumer. That individual can present information and witnesses, and also stand in for the consumer. So the Federal Appeals Entity can actually communicate directly with the authorized representative, even if the consumer is not on the phone or not available. Now, as an attorney, this is one of those places where, again, it's important to note what your role is and what you are comfortable doing. If you are an authorized representative for an appeal and you are not a lawyer yourself, you're actually potentially jeopardizing the legal rights of an individual. If you're a navigator or an assister or a family member or a friend, you certainly can support a consumer going through the appeals process. And you can work with them and you can help them fill out a form. You could even appear at the hearing as a witness and provide information without being an authorized representative. So I just want to be really clear here. And I think it's important to note that, assisters and other support individuals in a consumer's life that are helping with an application can assist without being designated as an authorized representative. So assisters and family members and friends can take on roles like explaining the appeals process, explaining when someone has a right to an appeal, helping fill out a form, mailing in a form, helping them understand deadlines, and maybe even referring them to low cost or legal aid in their area. What I would suggest is that assisters really should not be providing legal advice. And they don't have a duty to represent a consumer in an appeal, sign a request, or file an appeal. Again, they can do all of these in a support role without actually stepping into the role of authorized representative for the consumer. So it's really important that while assisters are not prohibited from being authorized representatives, that particularly if you're a navigator funded through the federal marketplace, that you actually can't use federal navigator funds to act as an authorized representative. But even if you're not in one of those roles, again, I would really think carefully about what is your role in an appeals proceeding and whether it might be better to be a support person and a witness rather than an authorized representative. So let's go through a couple of examples here. We have a consumer, Ashley, who couldn't resolve her application through casework and now wants to appeal. David is an assister and helped Ashley file her appeal and then followed up with the Federal Appeals Entity to make sure it was received. He's doing this in a support role. So again, can he participate in the hearing? Absolutely. He could be a witness, but we really think that if he's not a lawyer, he should not act as an authorized representative. And since the consumer's legal rights are at stake here, she may want to have an attorney represent her. If she's low income, she might be eligible for free assistance from her local legal aid organization. And again, we'll make sure you get this link. Or if she's not eligible for legal aid, sometimes there is pro bono assistance available through state bar associations, or for other reasons, she may decide she actually wants to hire an attorney. So again, what this section has gone through is how to file an appeal, what the different roles of individuals can be in assisting the appeals process, and then how to get the appeals going. So once we've gotten through that, let's take the next set of steps into the actual appeals process and how decisions by the appeals entity are implemented. There are two stages of an appeal. The first stage is what's called informal resolution. And in this stage, the Federal Appeals Entity is going to work with individuals who've appealed, called appellants, to resolve their appeal informally. This is usually done by contractors to the marketplace. Those contractors review the facts and evidence. They'll often have a phone conversation with the consumer and the consumer's authorized representative if he has one. After that hearing and after considering the information, there will be an informal resolution notice. And this is going to describe the proposed resolution and the decision of this first stage. If the consumer is satisfied, great, appeal is over and done, a decision will follow, and that will be implemented. If the consumer is not satisfied with that proposed resolution, the consumer may request a formal hearing and then go into stage 2 of the appeals process. And the second stage is a more formal resolution or hearing. In this case, written notice will be given to the consumer at least 15 days before the hearing date, unless the appeal is expedited or the appellant requests something earlier. These hearings are conducted by telephone. That was actually happening before COVID and will probably continue afterwards. Some of it's just a geographic issue of the number of appeals across the country and the number of people who are able to hear these appeals. In this case, for the second stage, it's a federal hearing officer, someone who's actually employed by the Department of Health and Human Services, who's presiding over the hearing. In the second stage, the Federal Appeals Entity is also conducting what we call a de novo review. It's a fresh look. The Federal Appeals Entity is not bound by the decision that was made in the informal first stage of the process. In this hearing, consumers can present witnesses and evidence. It could be the same as an informal hearing, as the informal stage. It could be new. The consumer and witnesses will provide testimony under oath. There are certain situations when an appeal can be expedited or moved on to a fast track. This will occur if a consumer requests it and if the standard time frame could jeopardize the appellant's life, health, or ability to attain, maintain, or regain maximum function. Now, I'm emphasizing this. You don't see any question about financial consequences here, and we'll go through an example shortly that will sort of make that difference. If an individual wants something to happen on a quicker time period, they have to put that request in writing on their appeal request. Now, let's say they file their appeal on February 1st, and then something happens on March 1st, and they really need to get it moving. They had a change in their health. They can then actually update their appeal request and request this expedited basis, even after they have filed their initial appeal form. If the Federal Appeals Entity denies the expedited request, it has to give written notice to the consumer, and then the appeal will just continue under the standard timeframes. Okay, so let's go through an example here. We have Diane, whose tax credits were terminated due to an income data matching issue that wasn't resolved. So it's the end of the data matching period, the end of the 90 days. And so she has a final eligibility determination and she wants to file an appeal. While that appeal is pending, she would have to pay 100% of the premiums to maintain her coverage. And paying this would be a financial hardship for Diane. So can she request an expedited appeal? Unfortunately, no. Financial hardship alone is insufficient to get on that expedited track. Can she receive tax credits during the appeal? Yes, if she requests them. Because again, she has a final eligibility determination at the end of her inconsistency period. So if we take Diane again with slightly different facts, let's say she has a chronic condition and needs monthly medication to maintain her current health status. So it's not a financial hardship is the reason she's asking for an expedited appeal, but rather a medical issue, a reason that would affect her health. In this case, she can request an expedited appeal because if she doesn't get her medication, her health could be at risk. And so in this case, again, she would note on her initial appeal application, or she would ask to update her appeals file once things are moving and request an expedited appeal. What happens at the end when you actually get a decision from the Federal Appeals Entity? After the hearing, the federal hearing officer makes a decision based on the testimony, other evidence, and the applicable legal rules. They'll send the consumer and the authorized representative, if there is one, a decision in writing. It's supposed to be issued within 90 days, but we have this little phrase here, or as administratively feasible. And so again, some people, unfortunately, it takes longer than 90 days to get a decision. The decision is final and binding on the consumer and the marketplace, but if the consumer is still unsatisfied with the decision, the consumer might be able to appeal it in court. Once the determination of the appeal is completed, if it's successful, the consumer is going to have two options. One, have the decision implemented prospectively from the date of that decision going forward, within some minor things about, selecting a plan and how those come into play. They can also request retroactive implementation, which is taking that decision back to the date the appeal was filed. So if someone files an appeal February 1st and they get their decision August 1st, they can either say, I want it to start August 1st and go forward, or I actually want to go back to February 1st. But if you go backwards, then the consumer's going to have to pay her share of the premiums for all of those past months. So again, this can be an individualized determination based on the situation of the consumer, whether they had medical bills during the interim, et cetera. So again, let's take an example here. And we have May, who was denied tax credits that would have started in January. She appealed the denial and was paying her premiums until she got the appeals decision. So can she get retroactive tax credits back to January? Excuse me. Yes, she can. If she prefers not to, she could just wait until she files her taxes and claim them on her next tax return. If she elects to go back to January 1st, her insurer can either refund her the excess payments she was paying or apply that amount to future months, reducing her payments from June forward. So let's walk this out a little bit. Let's say she didn't enroll in coverage during the appeals process. Can she get retroactive coverage back? Not if she wasn't, she has to go back either all the way or just go forward. You can't go back part way. So in this example, again, she appealed her decision in January. In June, she wins her appeal. If she wanted to go retroactive back to January, she can do that and pay her share of the premiums for that amount. But she can't decide, well, I didn't really use healthcare in January, February, March. I did in April, so I only want to go retroactive to April. Unfortunately, that's not allowed. It's all or nothing. You either go all the way back to the date that you appealed, or you say, okay, I'm just going to take it going forward. Let's take another example here. Benita's husband has affordable insurance through work, but the cost to insure Benita is too expensive. And she falls in what we call the family glitch. So when she applies to the marketplace, she's denied tax credits. Can she appeal? She could, but unfortunately, because this is a final eligibility determination. However, it's actually the law that prevents her from getting coverage, not something the marketplace did. Because of the family glitch, she's ineligible for coverage. And until or unless that's fixed, she's not going to win her appeal because unfortunately families in the family glitch don't get tax credits. So just to sum up, and then we should be able time to get to some questions. Here are a couple of resources for getting help with appeals. Again, individuals can call the call center to get information about the process, get some of those web links we talked about, and also understand what grounds they're eligible to appeal. The Marketplace Appeals Center can also answer questions about a specific appeal. So this isn't a general information line, but once a consumer has filed an appeal, they can call the Appeal Center to see if their appeal was received, to see what the next steps are, to get information about timing and other information. And again, if consumers want to find legal assistance to represent them during the appeal, we strongly suggest that they look into whether they might be eligible for free legal assistance through their local legal aid or legal services organization, or can look for other resources. So a couple of final points to remember. Consumers can submit an appeal online. They can fill out a form and mail it or fax it, or they can just write a letter explaining their situation. The first stage is going to be an informal telephone call trying to resolve the issues. If the consumer is unhappy with that informal stage, excuse me, they can request a formal hearing, and then decisions are mailed within 90 days after that final second stage hearing, or is administratively feasible after that. So again, here are some additional resources. We have a Marketplace Appeals fact sheet, some links to healthcare.gov that have some of this basic information about how to appeal, what's appealable, and where these forms are. And then just on the last slide, I'll give folks a second or two, but again, we'll distribute the slides so you'll have copies of all of these links. And I'm just going to give you our contact information for myself as well as folks at the Center on Budget and Policy Priorities. Again, I'd like to thank them for inviting me to present today. And at this point, I think we'll have time to turn it back over for questions.
Thank you so much, Mara. We did have a couple questions come in. The first question is, does the Marketplace call center offer to submit a
Does the Marketplace Appeals Center take appeals? Was that the question? Sorry.
Marketplace?
Oh, call center. Sorry, this might be my internet breaking up. I often have a bit of a problem, often at this time during the day. Ina, can you still hear me?
Yes, I can. You know, it was me. My cat unplugged my my webcam, which had no speaker. So,
sorry about that. We locked my dog out of the room where I'm presenting. Okay, so the Marketplace call center cannot file an appeal for a consumer at this time. The call center can provide information about what's appealable. They can share links about where to get information, and they can share links to get to this online appeals form or the form that someone can print out and submit. But at this point, the call center will only provide information. So a consumer is going to have to take that next step and either submit an online appeal herself, print out that form, mail it or fax it, or just write a letter and mail it or fax it.
And what is the process for requesting a continuation of tax credits?
If you're using the online form, or I also believe the paper form that you're going to mail in, there's a box to just check that says, do you want to have these continued? Again, I'd say if a consumer doesn't know at the time that they're filing appeal, they can call and update their information. If a consumer is just submitting a narrative appeal, meaning they're just writing a letter, again, I think it would be important to note in that letter that the consumer wants to have their tax credits continued during the appeal.
Great. And let's see. If Medicaid is still pending for a child, can that child have Marketplace insurance until a determination has been made?
No. Generally, once the Medicaid application is sort of in process, they're going to have to wait out the decision from the Medicaid agency. Usually it's supposed to be made within 45 days of the date of application. If the child has a disability or individual has a disability, states are given a little bit longer of time. But once that once that Medicaid application decision is made, the coverage actually goes back to that date that the application was submitted. So again, if I submit an application on March 1st and I don't hear until April 10th, my Medicaid eligibility will still be backdated to March 1st. So if I've had any medical or healthcare claims, I'll be able to submit them and get reimbursed. And in fact, in most states, Medicaid eligibility also provides 3 months of retroactive coverage. So that's actually more beneficial than what the Marketplace does. A few states have gotten permission from HHS to not provide retroactive coverage, but the majority of them do. So there actually are some benefits to getting eligible people into Medicaid. And also, as you said, well, not as you said, but the question, could they get tax credits? They'd have to pay for tax credits during that time. So Medicaid is often a more robust coverage at a lower price for individuals. And that's why we really feel strongly that eligible individuals should get into the Medicaid system rather than the Marketplace at this point. The other concern is legally individuals can't have both Medicaid and Marketplace coverage. So if an individual applied for Medicaid and was somehow getting tax credits and then gets their Medicaid coverage, they'd have to repay those tax credits likely.
And in a similar thread, if a child is determined not eligible for Medicaid after the application has been sent to the state, would they be eligible for Marketplace coverage back to their original application date?
Yes, we certainly believe that that application date should hold as the date of the application. And again, if the Marketplace decided otherwise, that would be a valid reason to appeal. I haven't seen this in practice in a while, but generally that was what was supposed to happen. Again, if we take the situation that I said, March 1st application, April 15th date of determination, and let's say in this case, it was a denial of Medicaid eligibility, that child should be able to get back coverage in the Marketplace till March 1st. The question is, do you want to pay back those premiums for those for that prior month, or just start prospectively going forward? And that's going to be an individualized determination based on the facts for that child and family.
And are there any times an appellant can receive APTCs if they fail to send in requested documents to prove eligibility?
So it sounds like I'm going to read into this a little bit. So an individual gets a temporary decision with a data matching inconsistency because of immigration or citizenship or income. During the pendency of that inconsistency period, which is usually 90 or 95 days, the consumer, depending on which inconsistency it is, may have temporary APTCs, but they're not going to be able to appeal until the end of the inconsistency period. When those 90 days run out, if the consumer has resolved the inconsistency, they'll get a final eligibility determination. And if the consumer has failed to send in documents, they're going to get an updated final eligibility determination based on, whatever facts the marketplace has and evidence at that point. So in either of those situations, when that inconsistency period ends, the consumer then will have a final determination and can appeal at that point. I think that answers the question.
And if it doesn't, please feel free to elaborate on your question to the question asker. Does the consumer owe back APTCs if they request to use them during the appeal, or ultimately deny the APTs via the appeal, and then go through the APTC reconciliation at the end of the year?
So yes, it is a possibility that if you request tax credits during your appeal and your appeal is ultimately unsuccessful, or the appeal finds you are eligible for less tax credits than you were receiving during the appeal, it is possible that you will have to repay those. Unclear, we haven't heard of situations where healthcare.gov has requested the repayment. And I think it's just due to a number of factors, but I don't know honestly what would happen at reconciliation, but my best understanding would be is you would still have to reconcile your income at the end of the year. So if you received more tax credits than you should have because your income ended up being higher than predicted, then yes, you likely will have to repay them through reconciliation, which is less an issue about the appeal and more an issue about how reconciliation works when sort of final income, as opposed to your estimated income, which you provide when you enroll.
And how would an assister go about becoming a third-party representative for an appellant?
The third-party representative was actually at the call center. And so if a consumer wants to have an assister designated as a third-party representative for the call center, I think it's with the third-party representative, and request that that person be added to the application as a third-party representative, which would let the third-party representative assist with the call center. If the consumer wants to have an assister designated as an authorized representative for the call center, again, has to be with the consumer's permission, so likely on the phone at the same time. And then in those situations, the assister can actually, act on behalf of the consumer. I'm not sure a lot of assisters are going to want that responsibility, to be perfectly honest. And then again, the authorized representative in the appeals process is even a higher level of sort of responsibility given the legal rights it issues. So again, it can be done with the consumer's consent, but in my suggestion would be is if you are not a lawyer, that you're probably more likely to serve as a support for the consumer during the appeal and perhaps serve as a witness and help gather documents rather than be an authorized representative. I hope that clarifies.
Great. Well, thank you so much. And I believe that is all the questions. So again, thank you so much, Mara, for this incredible presentation. As a reminder, we'll be distributing the materials from today's session via email, and we'll post everything to the Beyond the Basics website at www.healthreformbeyondthebasics.org. You can find additional resources on the website, including reference charts, guides, and frequently asked questions. If you have questions or need assistance, please email our Beyond the Basics contact email at beyondthebasics@cbpp.org. And with that, we'll bring today's webinar to a close. Thank you again, everyone, for joining us today.